Hello, and welcome to our first episode of Sovereign Citizens Threat to Justice. Now, some people are going to say, shouldn't there be a question mark at the end of that sentence? And I'm going to say, no. I'm going to go by the findings of the FBI and a couple of other really well-respected groups who have said, we've looked into it, and they are terrorists. So we're going to just say they're a threat to justice. But let me just say that one of the groups that I see who could get a lot out of listening to this podcast, or I have a lot to offer them if they'll listen, is that I'm going to explain why whatever you invest in that podcast, whether it's be $100, not the podcast, the program, let's say, of being a sovereign citizen, $200, you are setting yourself up for financial ruin. So the programs are very much, unfortunately, tilted toward people who are in financial trouble. And along with them is their twin brother, people who have never succeeded anywhere in life, who think life has passed them by, that it's unfair, and they really would have made something of themselves if they'd only been treated fairly. Anybody who has that belief almost always, if they're male, has a stint in jail. So that's who this religion cult sends its messages to. Now, there are going to be people who say, but wait a minute, I read it, and the word salad, I didn't understand it, but it seemed to make sense. No, it doesn't make sense. It is word salad, it's nonsense. If you gave me an hour, I could write up something equally as brilliant sounding that also has no legal value at all. And we'll get back to this because we're going to take it in a kind of a logical order, but I would just say, if you're just thinking about it now, why would you ever take legal advice from a book, from a podcast, from a person who has never gotten a law degree? If they've never graduated successfully law school, and I would better yet say, and then passed the bar, why would you take their advice for anything? If their advice was worth anything, they would have passed the bar. And yes, in fact, many states, if you think you've got it, if you think you've got the wits yourself, even though you haven't graduated from a law school, you can take the bar and see if you'll pass it, and you'll never pass it, not in a million years. So one of the examples I saw of this yesterday, and I wanted to explain this to you in hoping that you'll keep your finances to yourself if you're thinking of investing in this scam. I saw a young woman yesterday in her podcast on YouTube, and she was encouraging people to become or to abide by the sovereign citizen rules, and she showed a police stop and then showed how the police, even though the person explained all of the script that they're given, the police just went in and took the guy out of his car and threw him on the ground and took him off to jail, which is what always happens. And every explanation that the book or program that you have in front of you that says, here's why that's illegal, it's all wrong. It's all wrong. So let me first go back to her. And she, in order to be able to prove that her theory that the search was illegal was correct, she just read from the Fourth Amendment, and it says that people are prohibited from doing unlawful searches and seizures. Well, that's true, and so she said, there you go, it's all done. The inquiry into this is all done. See, so the police can't go into your car. They can't search your car. You just tell them no, and you have the right to drive away, and blah, 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 blah. Now, I don't know if she's an idiot or a fraud. She's one of those two. I don't know if she's intentionally lying to you or is she smart and she's just trying to get you to buy her book and make some money? But either one of those is a horrible way to live your life. But I want you to know that her analysis shows why she should not be listened to ever again. Ever. Because by looking at the Fourth Amendment and not realizing that when you go to law school, you learn all of the exceptions, or as my friend in law school used to call it, carve-outs of the Fourth Amendment. So yes, that's the general rule of the United States, but if you think that that's it, that you've now learned what goes on in court, or you are now qualified to expound on search and seizure, you are sorely, sorely mistaken. Because there are many, many exceptions to the search and seizure prohibition of the Fourth Amendment. And the Fifth Amendment has even more, but we'll get to that later. But the Fourth Amendment has time, place, and manner prohibition. So, in other words, you may be going just outside to speak and be assumed, hey, Fourth Amendment, I've got the right to do this without anybody grabbing me or searching my car. I'm just driving down the street to go for, let's make it simpler. Say you're going out for a hamburger. No, nobody can stop me. I'm driving down the street to get a hamburger. So Fourth Amendment says I cannot be stopped. That's what the sovereign citizen might want you to think. Well, that's just clearly wrong. If your lights are out, you are a traveling, we'll get to that later, danger. So as you move down the street, you are a danger to the public, and the police officer has the right to pull you over and stop you with no more than that. Let's say you're swerving, and it may be hard to believe, but there's actually a legal definition of how much you can swerve, how many times, and how far into the other lane, and it changes all the time. But your lawyer needs to know that, and if you don't, you will think, hey, this is illegal. I'm being pulled over for swerving. Why? How could they do that? There is a way to do that. If you're swerving, that would be a hazard driving down the street, and the police certainly have the right to pull you over. Now, these cheaters that are trying to get your money will say, well, don't worry, you just tell them this, this, and this from the script, and they cannot go in your car. Anything they find will be thrown out in court. That is absolutely false. They have never won on that grounds. They have, out of thousands of cases where people have tried to be sovereign citizens in courts, they have never won based on their sovereign citizenship. They've only won cases where, let's say the police didn't show up to court and they would have won anyway. There are a few of those, not a lot. But the point of this is, let's look at this woman who was telling you, send me money, I'll help you join the sovereign citizens. And back to her teaching that, look, the Fourth Amendment says you are entitled to be free of unreasonable searches and seizures. That proves that they can't stop you or do anything to you. No, it doesn't. What an idiot. What about if the officer is talking to you, and as you know, their flashlight's already zooming around the inside of your car, which is perfectly legal? It's already been litigated. Is that a search? No, the flashlight does not search the car. It just allows the officer to see better. You have to know that, by the way, to graduate law school. So when she tries to pretend that she knows the law of search and seizure, boy, is she selling you a bridge in New York. And the point is, though, if he's going back there and he sees a syringe and maybe a spoon and some other equipment used for injecting or ingesting illegal drugs, He's got a right to open the door and look at it, pull it out, take you out, put your hands behind you, and investigate what's going on. Now, one of the craziest, just most ridiculous, it only makes the alleged sovereign citizen look like a fool, is this barking that they are instructed to commence, yelling, "I do not agree. I do not agree to this. I did not contract with you for any contractions that babies have or any contract that somebody might have signed, and I will not." There's no sense to that at all. I'm very sorry, by the way, and I really am. If you paid money for a program like that, where you paid money and you got a book that said if you do that, it has some value in getting you out of it. It has nothing. It will never help you. It makes you look like a fool. Maybe rightfully. And so any of these speeches that they've taught you to go through will never help your case, in my opinion. I've never seen it help a case, and of course, what better do you want than your batting average is 0 for 2,000, or in other words, 0.000. That's what you're batting by being a sovereign citizen. And so we're getting back first to the searches and seizures, and that's why her statement that the Fourth Amendment is all you need to know about searches and seizures. No, it's a 1-year course in law school, with 3 classes a week, each one an hour and a half, and that's just the school part. You also have to read a 2,000-page book during that time. And that's how you pass constitutional law, not by reading part of one paragraph of the Constitution, so that you have to be able to discuss, without being told this is what you're looking for, you have to be able to discuss. This looks like a time, place, and manner question. Did the person driving have the right to have his radio on real loud and not be pulled over? Well, I don't know what time it was. Oh, it was 2 a.m. No, you can't have your radio on as loud as it'll go and drive down the streets at 2 a.m. Time, place, where was he driving? Oh, in a hospital. He happened to take a shortcut over to the hamburger stand through the hospital parking lot. So there were patients trying to sleep, and he's got his radio up as loud as it'll go. And, of course, he's got one of those, 15-inch woofers and things like that. So boom, boom, boom. No, you can't do that. Even though the Constitution says you're entitled to be free of unreasonable searches and seizures, the waffle word or the hinge word is unreasonable. And it's not unreasonable of the police to stop you driving through the hospital parking lot, waking up all the patients at 2 a.m. Time, place, manner. What about if you were driving at 60 miles per hour in and out of the lanes of the hospital just because you like driving like that? So you're just practicing, recreating the driving chase scene from the movie Bullet, and you're going in and out of the rows of the hospital. Well, even if it was during the day so that the noise wouldn't bother people, and it was such that there was nobody around so it didn't wake them up or anything like that, it was dangerous. So the manner in which you were behaving, or in this case operating your car, was dangerous, and they can still pull you over for that too. And then we already have been on item 4, which is plain view. So if the police, while they're talking to you or investigating why you're behaving like a lunatic, if they see something in the car that seems to them indicative of illegal activity, and that can either be drugs or a firearm or anything else that might be an indication that you're involved in criminal activity, they can look into it, and because you're on the side of the road, and if you were foolish enough, you could hit the gas and take off, the police have a lot of leeway into saying to you, stop right now, turn off the engine, and if you don't do that quick, they just open the door and grab whatever it is they see that they want to preserve for evidence. Okay? So that's why you don't want to be a fool and get involved in these courses, because they are just scamming you. How should a court behave towards a person who walks in and intends to impose his beliefs upon the court? He intends to impose his beliefs that as a sovereign citizen, his rules are superior to the court's rules. I heard one supposed sovereign citizen today say that she follows the law of God, and since God's law is above all man, she doesn't have to follow the court's laws. She only has to follow God's laws. The judge was ill-qualified to respond to that. If he listens to this podcast, he'll be better qualified next time. But the first thing is that should have been stopped right at the first note, right at the moment the case was called. The first time a person walks into your court, if you are a judge, which I was, no longer am, the first time they announce it, my belief is before they get the end of the first word out. So if they say the word, Your Honor, by the time the word Honor is out, you should have already had them sitting down. And I would do it politely, but you just would say, Mr. Crenshaw, could you have a seat, please? Court has not started, and you will not be running the court today. And here's your first big indication of whether this thing is going to turn into a brawl or not. If he sits down, great. Everything's fine, and I would immediately go on to the next case. It's over, as far as I'm concerned. But if his response, rather than to sit down, is to argue with you and tell you, wait a minute, Your Honor, I have free speech rights, and I'm boom, 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 I would stop him there, and I would say, Mr. Crenshaw, stop talking, right while he is talking. And I would do it until he stops talking, and that includes even if I have to have the bailiff come over and have him sit down in what I used to call in my courtroom the special chair. And that's the one to my left where usually witnesses sit or the extra members of the jury, but I have him sit in the chair to my left, which is out of the audience and just in front of the jury. And I have him sit there, and I tell him I'm going to deal with his outburst when I've gotten the court's emergency things out of the way. So now he's sitting there with nothing to say. Again, if he really wants to go double or nothing, he can start arguing and voicing from where he is. And that's why, and this is my first rule for all judges, I think it's the second rule. First rule would be you begin control of the courtroom from the first moment. You do not wait for the sovereign citizen to have you in the middle of a logical tautology where they just ask you a question, and after you explain it to them, they just ask you the same question again. The point is that if this person is still at the left doing that, you've got a problem in that you have not yet notified the court, unless you have one of these systems that has the rules written outside or something like that, which is great. But if you don't have that, mine did not have that, you have to let this person know that there are rules for appearing in court and that there is no choice as to whether they want to abide by those rules. And that if they argue that they are not going to follow those rules, they will be invited to leave the courtroom and suffer the consequences, because it's not an excused leaving. Or I'm going to put them in jail. I'm going to find them in contempt, hold a contempt hearing, and put them in jail. Truth is, I never did that with anyone. I never put them in jail. I told lots of people there was a contempt hearing for them and that it would be in an hour or after lunch or something like that. But it seems that no matter how firmly entrenched they are in their beliefs about being a sovereign citizen, all of a sudden it disappears when my clerk gave them the forms that we had for incarceration intake form. And he would give it to them on a pegboard with a pencil tied with a piece of paper to it so they couldn't steal the pencil. And he would have them fill out all the paperwork that we were going to use when we sent them down to the jail. And we had a collection of those. I think we had about 30 or 40 when I had to retire. But people got smart. Somebody said something about lunch smartness. They got lunch smartness, and when I came back after lunch, all of a sudden they had a different attitude. But the attitude is what you need to tell them before you have any right to punish them in any way. My belief is that if you have not instructed them as to what it is they cannot do, you have no right, in my opinion, and I think other judges would very much argue. But in my opinion is you don't have the right to do anything to them other than ask them not to do it again. Lack of notice would, I guess, be the constitutional argument there. But I would just beg you, if you're going to punish somebody and you have not explicitly explained to them before they violated the rule what the rule is that they're facing, don't do it. If you insist on doing it, give them an attorney. Assign them one from the public defender if you have to. Let that public defender argue the point and let it drop. If you didn't warn him what kind of violation was going to risk him landing in jail, and if you didn't explain to him or her that they'd risk being in jail if they violated, you have no business sending them anywhere. So let's go back to the example of the guy who walks in, and let's say that you have him sit down and he's quiet. Here's the rules that I go over with the court now every time so that I can avoid the sovereign citizen hoedown. First thing I want to do, first and foremost, well, I think first, we already said first was that you start it when they walk right in the room the first time. Okay. Second is you have to explain to them that there is no right on their behalf to speak. There is no right for them to speak in the courtroom. The only person that has the right to speak and therefore can temporarily give it to somebody else and say, I'm going to stop speaking here, you can speak, is the judge or the bailiff before the judge comes out. But I'm saying when the judge is on the bench, it's the judge. And you need to explain that to the crowd. Probably not to the prosecutor or the public defender. But to the crowd, you must let them know that it doesn't matter what they read somewhere else. There is no excuse, and there is no, well, I know I wasn't supposed to speak up, but I really wanted to tell you. There's no such thing as that. Zero. Now, I've seen the heavy-set judge with the glasses falling off. She'll sit there and let them just interrupt her and go on and on about liberties and things like that. Well, that's how you lose control of the court. Or some would say that's proof that you've already lost control of the court. You don't do that. What you do is you tell them before anyone has tried to make an attempt on the ownership of the court, you tell them there is no right to speak unless the court addresses you, and there is no exception to that. No matter what they've read somewhere else, they will not be allowed to use that as an excuse and therefore violate the right of somebody else who is speaking or of the court to have nobody speaking. Because it is the court's right, because as judges, we sit up there and we read. We read the cases, we read the police reports, we read medical reports, we get notes passed to us from our trusty clerk who says the punishment for what he just admitted to is 6 months. So we get those all the time. And so we're reading, and if we're not making a sound, if we're not speaking, that does not mean that the court is out of session. It means everyone has to be quiet to allow the judge to read. And there is a small crack there where an attorney who knows is that, Your Honor, I have something I want to take care of, or, I don't like hearing that when I'm reading. It gets me mad, but I usually remind them, I'll say, let me finish reading this. This is somebody else's case, and it's very important to them that I read it. So that's my way of nicely explaining to attorneys who try to put their caseload over in importance the case that I'm reading on the bench. And I'm letting them know, don't do that, or every attorney will be saying, can I go now too, Your Honor? I have a case upstairs. No, just sit and wait and let me read, and we'll go on with it. That is so important for a person to understand that it goes hand in hand with Rule 2B, we'll call it. And that is that interrupting the judge, okay? Interrupting the judge, if the judge is speaking and you just start talking over him or her, the judge, you are done. There is no warnings to that behavior other than this one that you're giving the court at the beginning of the day. And you let them know this is the final warning. So if while I'm speaking to you, to someone else in the court, to the bailiff, while I'm speaking, there is no, I'll just throw my voice up here and interrupt. If you do that without warning, without further warning, I will have a brief hearing to nail down the facts, make sure it was you, not somebody else that was speaking, and I will, if you're found guilty, I will likely jail you. And you may not use the excuse about, this is my first time in courtroom, I didn't know, I was nervous. That's fine if I hadn't given this warning, but I just warned you that all of those do not work. I have to get perfect, if possible, treatment of the law for the people that are in here today to have their cases heard. And I'm not going to be distracted while I read the facts of their case and the facts and the charges against them, because you felt you had the right to just pop up and have yourself heard because you read it in a book that you bought on eBay or on Amazon. You don't. You have the right to follow my rules. Let's go on from there. So we've now talked about you don't talk when it's not your turn, and you never interrupt the judge. What should you call me? Now, you probably heard from television some wrong answers to that, but in the state I was in, the only correct name was Your Honor, not judge, like we heard the O.J. Simpson lawyers do over and over. That's not correct. Any other name other than Your Honor is incorrect. So you refer to me as Your Honor. And yes, it is a violation of rules, etc., if you decide, as I've seen sovereign citizens do, decide to call me by my first name or by the nickname that people used to call me on the playground, or some name that you think is good for you, or you call me hey, or something like that. That's a sign of disrespect to the court. And I don't let anybody disrespect the court, ever. Zero. I've got 1,000 batting average for that. You don't disrespect the court ever. So, you do not call me by any name. Now, here's a third issue for you judges that you really, I don't know if the word is getting out or not, but I see this on videos of sovereign citizens in the courtroom, and this is just almost unbelievable. How many times have you seen or had a sovereign citizen, and they don't have to call themselves one of those, you're just playing the same script, start challenging you, or very close to that, inquiring as to your beliefs, as if somehow they think that they have a right to know what you think on a certain issue. Well, there are many, many prohibitions on that. One would be that you're not allowed to start offering your opinion on cases that aren't before you. So when they start asking you about, well, what's your opinion on it doesn't matter. That case is not before you, and you are not, and I mean you are instructed not by the state rules to venture out an opinion on that. It's not before the court, and the U.S. Constitution says that case or controversy only. You're allowed to give your opinion on the case in front of you when you've got all the facts and law before you, and not before. So when they take the attitude that, well, Your Honor, you say this, but I want to know why you don't say that, you have to, right then and there, I would give them one warning, because really I don't know if that was covered by the announcement and warnings I gave earlier, but I would say, sir, you are not an attorney yet. You're just a litigant in traffic court. So I'm not going to demand that you comply yet with the competency of an attorney. But now I'm telling you that you have to behave as though you're an attorney in court. Now, attorneys in court do not ever challenge the judge as to their knowledge of anything. And they know that the Constitution prohibits the judge from venturing out with you posing them hypotheticals and the judge trying to answer that. That doesn't happen. It can't. So what I'm telling you to zero it in on you is that you don't have that attitude, and you don't have the right to ask the questions. It doesn't matter what attitude you exhibit. If you start asking the judge, me, questions about what are my beliefs and why is it I don't do this or that, that is not an acceptable or permissible question before the judge. And I might give you a warning, or I might decide this is the warning, and you're doing it anyway. So, therefore, you're in contempt, and you might just be having a vacation tonight at the expense of the county at our hotel, our Gray Bar Hotel that we have in downtown. So, let's go on from there. So they are not to, as I see them getting away with in too many courtrooms, they are not to banter with you and argue with you. And that is another one of the very saddest parts of that box of BS they sell you as sovereign citizenry, that they say that, well, if you can bicker, if you can argue back and forth, that's the same as delaying your case, and that will result in you winning. Well, it might delay your case. It does take time for a judge to get together all of the things we have to do to punish you for interrupting the court and disrupting justice. But it won't help your case ever. The only thing it'll do is probably result in you receiving additional punishment. Because there is absolutely no right to disrupt the court. So we're talking about raising questions, stating things, giving your opinion, asking questions. Anything you do, if you're not sitting up at the front desk and you haven't been recognized by the judge, is a breach of the court ethics, and you will be subject to contempt. I don't know if the judge will hold you in contempt. Depends on the judge. But you certainly are making yourself in the crosshairs. You certainly could end up receiving a contempt sanction on that of maybe 5 or 10 days in jail or maybe more. So you have no right to speak in the court. And you have no right to lecture me about that there is a First Amendment that says, you have a right to speak. Well, we all know that is a conditional right. You can't yell fire in a crowded theater, right? So we know that there is no right for you to walk into the courthouse and speak until your case is called or until roll call is called and you're going to just answer up and say, yeah, I'm here. But there's no right at all for you to bring up anything you want to the court until it's time for your case. Think how unfair that is to the other litigants. If Joe is getting ready and they're going to call his case and he's all excited and he's got his paperwork and he's walking up to the front, and during that period you interrupt and say, Your Honor, I want to know why, if the plaintiff in this case isn't here, why hasn't my case been dismissed? If I had given you the lecture about don't interrupting, that would have gotten you in jail. But if I haven't gotten that lecture to the public and to the people in the audience or whatever yet, then I would give you one and one only, one warning. And I do mean one warning. And after that, I would, if you did it one more time, or if you tried to do the string on about where I say don't do that, it's not your turn to speak. If you tried to use but Your Honor, what about the fact that if you did that, or even worse, if you said, Your Honor, I think you don't know the First Amendment. The First Amendment says I have a right to speak, and teach the judge law. It just ends right there. That is it. If you're going to teach the judge law, I will have you come to the front. I will have you questioned, tested, as to your knowledge of law as compared to mine, and I promise you, you're not going to pass me. And that would go for Eric Martin, who says he's been studying for 28 years and still knows nothing. That's amazing. How does he do that? How does he say he's been studying law for 28 years and yet, then why hasn't he passed the bar? Or why hasn't he taken the bar? Well, he hasn't. Or maybe he has. We don't know. He might have and just failed. So the interesting thing is that should clamp down a lot of the behavior. Now, when that behavior gets pointed towards other litigants, the urgency of taking in the situation, assessing what's going on, and immediately stopping it is nothing but urgent. That happens, or that mostly happens, when the sovereign citizen's case has been called. He or she is over there at either the plaintiff's table or the defense table if it's a lawsuit, and all of a sudden they start yelling at the other party, and it's almost always, in my experience, they yell at them when the other side is trying to put in their evidence. They've read somewhere in their script that is the time to really just jump in there and just, Your Honor, I object to the document she's trying to put in. She wore a red sweater the whole time. We all know that. I am of two minds whether at that point I would just immediately bucket them or would I give them a warning. I don't have an answer right at this minute, but I would immediately tell them, stop. You have no right to speak right now anyway. So no matter what your beliefs are, you have no right to express them now. she has a right to, without interruption, provide her exhibits to the court. And more importantly, you need now, if you are acting as your own attorney, now this would be a situation where the person has been appointed their own attorney. You need to know that there's no such thing as I object because I don't like it. Objections follow the rules of evidence, which you are obligated to know, sir. You are obligated to know the rules of evidence of this state and to voice your objection in accordance with those rules. So that is what most judges like, and this is the way I like to do it, is you may state your objection and then immediately the grounds, and by grounds, I'm not talking about a talking objection. By grounds, I would just say, you can say objection, relevance, and wait for a ruling. If I rule on it, it's done. Now that is the biggest and worst offense that all sovereign citizens make. Someone either has not told them or has misinstructed them, if that's a word, that it is okay to argue with the judge's ruling, that you can just pick it up and say, but Your Honor, what about? Absolutely not. That's right there a violation. That is right there a contempt, and it could get you in jail or a fine. So you do not, once the judge has ruled on your objection, so again, you're going to say just objection, relevance, the judge, me, is going to say overruled. And that means that you did not get your way, that I believe the other side can still put the evidence in before the court. You're done. If you make one squeaky noise in protest and don't listen to that book that says, well, you just have to learn to do it like this. You just have to say, well, Your Honor, I was wondering, did you understand that? No. There's no argument about what I understood after I've ruled. After I've ruled, that matter is over, and that document's coming in. I used to have a really dishonest scumbag prosecutor that had a trick that he used to pull, but man, oh man, this is when I was a lawyer for criminals, and boy, I had the greatest way ever to just stop him. Jeez, it was so good. He hated me. He still, to this day, he still tells people how much he hates me, and it's been 15 years. And the only reason he hates me is because I skunked him. I didn't do anything illegal. I just made him look like an idiot every time he tried to do something illegal. We're back. So here's what you're going to do in the court when you are sitting and the other side is putting their exhibits in. You don't say a word except the objection. And now, if the court inquires of you, so you say, Your Honor, objection, relevance, and the court says, what is your objection and relevance? That means I don't understand your argument, but there might be one there. Explain your argument. And the first thing you better be able to do, because it's the way that you answer, is you better be able to cite the law on evidence without looking something up, without going to your phone, without going to your iPad, without using your computer. You should be able to say, well, Your Honor, as we know, the rules of evidence under 352 say that any evidence that's more likely to that's likely to confuse the jury or more likely to confuse the jury than to aid the trier of fact should be excluded by the court. Your Honor, I think that document, since it has about 12 different people writing in it what their opinions are, I think it's going to confuse the jury as to who is saying what, and they will come out with the wrong opinion of what each of our views are. So that would be a great argument. If it's true, see, that's how it's done. But to just say, well, Your Honor, she was late this morning getting here. I had to wait outside. It's not the doors open